Welcome, my fellow attorneys, to the National Bankruptcy Academy video series. I'm your host, Robert Schaller, an attorney with over 34 years of experience and a registered certified public accountant. Today, we'll be discussing Schedule D, secured creditors, with a line-by-line analysis with real-world commentary. I hope you enjoy the video. A debtor's schedule of secured creditors is officially titled Official Form 106D and is commonly referred to as Schedule D. Creditors who have claims secured by property, or just Schedule D. Every Chapter 7 debtor must file a schedule of liabilities that includes the debtor's secured creditors. It is vital to distinguish between secured creditors, which are listed in Schedule D, and unsecured creditors, which are listed in Schedule E/F. The creditors listed in Schedule D are limited to those creditors whose claims are secured by a lien or other security interest against property owned by the debtor. The property securing the debt is sometimes called collateral. Liens can be either consensual or non-consensual. A consensual lien is given by the debtor voluntarily and grants the lender a security interest in certain property designated by the debtor. The consensual lien secures the loan and typically grants the lender the right to take the property back that's securing the lien in the event the debtor fails to pay the loan. A non-consensual lien is not granted by the debtor. Instead, the lien occurs as a matter of law. Probably the most common type of secured creditor holding a consensual lien is the vehicle lender, whose debts are secured by a lien against the debtor's vehicle. Another common type of secured creditor with a consensual lien is a mortgage lender, whose debt is secured by the debtor's home. Examples of non-consensual liens include judgment liens, mechanics liens, IRS liens, and real property tax liens. The people or organizations to whom the debtor owes money are called creditors. A claim is a creditor's right to payment. When the debtor files for bankruptcy, the court needs to know who all the creditors are and what types of claims they have against the debtor. Typically, in bankruptcy cases, there are more debts than assets to pay those debts. The court must know as much as possible about the creditors to make sure that their claims are properly treated according to the rules. Creditors may have different types of claims, such as secured claims. Report these on Schedule D, creditors who have claims secured by property. Unsecured claims are another type. Report these on Schedule E/F, creditors who have unsecured claims. If the debtor's debts are not paid, a creditor with a secured claim may be able to get paid from specific property in which that creditor has an interest, such as a mortgage or a lien. That property, again, is called collateral for the debt and could include items such as the house, a car, or furniture. Creditors with unsecured claims do not have rights against the specific property. Many creditors' claims have a specific amount which the debtor does not dispute. However, some claims are uncertain when the debtor files for bankruptcy, or they become due only after the debtor files bankruptcy. The debtor must list the claims of all secured creditors in Schedule D, even if the claims are contingent, unliquidated, or disputed. So let's spend some time discussing those claims: contingency claims, unliquidated claims, and disputed claims. A claim is contingent if the debtor is not obligated to pay it unless a particular event occurs after the debtor files for bankruptcy. For example, if the debtor cosigns someone else's note, the debtor may not have to pay unless that other person later fails to repay the loan. A claim is unliquidated if the amount of the debt cannot be readily determined, such as by referring to an agreement or by a simple calculation. An unliquidated claim is one for which there may be definite liability, but where the value has not been set. For example, if the debtor were involved in a car accident, the victim may have an unliquidated claim against the debtor because the amount of damages has not been determined. A claim is disputed if the debtor disagrees about whether the debtor owes the debt. For instance, if a bill collector demands payment for a bill the debtor believes was already fully paid, the debtor may describe the claim as disputed. A single claim can have one, more than one, or none of these characteristics. On Schedule D, the debtor must list all creditors who have a claim that's secured by the debtor's property. Do not leave out any secured creditors. The debtor must list anyone who has a judgment lien, garnishment, statutory lien, mortgage, deeds of trust, or other security interests against the debtor's property. When listing creditors who have secured claims, be sure to include all of them. For example, include the following types of creditors: the debtor's relatives or friends who have a lien or security interest in the debtor's property, car or truck lenders, stores, banks, credit unions, and others who have loans to enable the debtor to finance the purchase of property and who have a lien against that property. Next, anyone who has a mortgage or deed of trust on real estate that the debtor owns. Don't forget contractors or mechanics who have liens on property the debtor owns because they did work on the property and were not paid. Another, someone who won a lawsuit against the debtor and has a judgment lien. Another parent or government agency that has a lien upon or lien for unpaid child support. Doctors or attorneys who have liens on the outcome of a lawsuit. Federal, state, or local government agencies, such as the IRS, that have tax liens against property for unpaid taxes, and anyone who is trying to collect a secured debt from the debtor, such as collection agencies and attorneys. A common question asks whether a claim can be both partly secured and partly unsecured. Well, the answer is yes. If a creditor's full claim is more than the value of the debtor's property, securing that claim, for instance, a car loan in an amount greater than the value of the car, the creditor's claim may be partly secured and partly unsecured. In that situation, list the claim only once on Schedule D. Do not repeat it on Schedule E/F. Creditors who have secured claims list a creditor in Schedule D even if it appears that there is no value to support that creditor's claim. The debtor must also determine the unsecured portion of secured claims. To determine the amount of a secured claim, compare the amount of the claim to the value of the debtor's portion of the property that supports the claim. If that value is greater than the amount of the claim, then the entire amount of the claim is secured. But if that value is less than the amount of the claim, the difference is an unsecured portion. For example, if the outstanding balance of a car loan is $10,000 and the car is worth $8,000, the car has a $2,000 unsecured portion. If there is more than one secured claim against the same property, the claim that is entitled to be paid first must be subtracted from the property value to determine how much value remains for the junior claim. Now let's turn our attention to this bankruptcy form with a line-by-line analysis with real-world commentary. I hope you enjoyed the video. Now let's begin looking at the form. At the very top of the form is the familiar box that identifies the debtor in both debtors, and also the bankruptcy court and the case number. So let's complete this for George and Martha Washington. So the first one is debtor 1, and that's George Washington. And debtor 2 is Martha Washington. And we're going to be filing this in the United States Bankruptcy Court for the Eastern District of Virginia. So let's use the pull-down menu. And we're looking for the Eastern District of Virginia, and here it is. So now let's click on that. The next box is the case number, and that would be filled in if this document is filed after the petition was filed. As a reminder, the date the petition is filed, the clerk of the bankruptcy court will be issuing a case number, and that case number would appear on all documents filed afterwards. But since this Schedule D in George and Martha Washington's case is going to be filed simultaneously with the petition, the case number is left blank. Over here to the right is the familiar box to check if it's an amended filing. So had this been an amended filing, we would click the box and move back over here and add the case number. But in this case, it is filing with the original petition, so there will be no case number. So I'm going to delete the number. And I'm going to uncheck the box saying it's an amended filing. Next, let's read the directions for Schedule D. And note, by the way, again, that this is Official Form 106D. Schedule D, creditors who have claims secured by property. But most people will just simply call it Schedule D. And the instructions say, quote, be as complete and accurate as possible. If two married people are filing together, both are equally responsible for supplying correct information. If more space is needed, copy the additional page, fill it out, number the entries, and attach it to this form. Now let's go down and look at the questions. The first question on the form is, do any creditors have claims secured by the debtor's property? And there's only two choices, either yes they do or no they don't. So if the debtor has no creditors that have claims secured by property, you check the first box. And then they simply print out this box and file it with the clerk of the court. But a Schedule D must be filed even if the debtor does not have any secured creditors. But in this case of George and Martha Washington, they do have secured creditors. So I'm going to uncheck the no box, and instead I'm going to check the yes box that the debtors do have creditors that have claims secured by property. And question 1 that says, if yes, fill in all the information below. So let's scroll down. To part 1. Part 1 is where you actually list all of the secured claims. So question number 2 says, list all secured claims. If a creditor has more than one secured claim, list the creditor separately for each claim. If more than one creditor has a partial claim, list the other creditors in part 2. As much as possible, list the claims in alphabetical order. Okay, so let's start down here with, see the number 2.1? That's helpful because when the judges will ever look at a particular document, if there happened to be any litigation on the document, you want to be able to specifically identify which creditor you're talking about. So they would say, for example, creditor 2.1 or creditor 2.2. So that's why they have that number. Now, in the case of George and Martha Washington, they do have 5 creditors, secured creditors, so let's list them. The first one is American Express. And then you want to include the address of American Express. And then the city. Now, jumping ahead, one of the issues is what happens if you have multiple claims by the same creditor. So, for example, imagine George and Martha Washington have more than one American Express card. Or George has an American Express card and Martha has an American Express card. So there's actually 2 separate cards. Or 3 or 4, depending on the fact situation. You would list those creditors separately. You do not lump them all together and say there's one big debt to American Express. You don't do it that way. You list them separately. So if they had 2 separate American Express cards for 2 separate accounts, then you list American Express twice. For example, at 2.1 and again at 2.2. And the reason for that is if there's ever a claims objection, that is later on somebody's objecting to the claim made by the creditors, they would object individually to the various claims. So it's important to keep them separately. Because, for example, a Chapter 7 trustee might object to one claim of American Express, but not the other claim for American Express. So they don't want lumping going together. Plus, the other information we're about to fill out may be different for each one of the claims. So for each creditor, as you can see below, it says who owes the debt, and some of the other boxes that we're going to fill in a second, that may be different for each of the different claims. So you want to keep the claims separate. In this particular example of George and Martha Washington, however, we are keeping each claim separate with a separate company, so you won't see that issue. Okay, now below the address and name of the creditor, it has the question, who owes the debt? Okay, so who's obligated to pay this debt? And you can see the choices, debtor 1 only, which would be George, debtor 2 only, which would be Martha, debtor 1 and debtor 2 only, and another interesting box that says at least one of the debtors and another. So that could be a debt where, for example, George has a debt but co-signed by a brother or a father or a mother, in which case you check that box saying the debt is owed by debtor and somebody else. If you note on the form, you don't have to identify here on Schedule D who that is, but in another course you're going to see that there's a separate schedule for those co-debtors. Well, but that's not part of this discussion. So in this particular case of George and Martha Washington, only George owes on this credit card, so we can check the first box. Down here it says date debt was incurred. So we fill that out.